Hey everyone, it's Ryan Leonard with Wolfnest Property Management, and today we've got a great topic for you. We're going to be talking about, is your Utah lease agreement strong enough? Now, I talk to a lot of DIY owners or do-it-yourselfers that have been managing their own properties for a long time, and they've been using the same lease agreement for the last 20 years, which can be a good thing or it can be a very bad thing. Having a strong lease agreement is crucial if you're managing a property, whether you're a management company or a do-it-yourself landlord. Now, managing a Utah rental property is going to be tricky regardless, right? It's whether you've got one property or you have 10, you're dealing with maintenance requests, maybe nuisance issues, tenants not paying, tenant turnover, deposit dispositions. There's a lot of things that go into managing a property. Now, one of the most important pieces of property management is having a strong lease agreement, something that is, well, I like to say almost rock solid. Reason for that, clear expectations from both parties, and everyone knows what is acceptable and unacceptable, whether it's behavior, actions, regardless. You just want to make sure that you have a very strong lease agreement. Now, if you're here in Utah, it is probably one of the most landlord-friendly states in the country, and so you want to make sure that you have a state-specific lease agreement. I talk to a lot of owners, and they send me a copy of their lease once they sign up with us, and upon reviewing it, they pretty much just Googled, lease agreement. They get one that's not state-specific, so you want to make sure that you have any laws or language in that lease agreement that are available to you that help protect the property and help protect the property owner. Now, crafting the right agreement, especially when you're here in Utah, can be pretty daunting. Now, the good news is with us here at Wolfnest, we have an attorney on retainer with us who has been in the game for 25 plus years. Also, he is kind of the go-to eviction attorney. I think he works about 85% of the entire eviction case workload in the Valley, and his lease agreements are constantly being updated. So again, one of the benefits with us here at Wolfnest is our lease agreements are always changing, new addendums, and going to be the most up-to-date with everything that we need to protect the property. Now, some of the things that you want to make sure that are going to be in that lease agreement, first one is going to be smoking. Now, typically there's going to be like a smoking addendum or some clauses that are going to be the agreement, but some of the things that it should include, obviously with the address being on there, is the tenant or their guest allowed to smoke in or on the property, even outside the property? Is he or she liable for any damage caused by this? You want to make sure that this is spelled out. Only cigarettes and cigars are prohibited, but can they have vapes? That's something that we see a lot of. If this is not outlined in the agreement, the last thing that you want to have happen is that, again, it's kind of vague, and if it does go to small claim courts and you don't have it clearly explained in that lease agreement, you may be the one footing the bill before that next tenant moves in. Next one is late fees. Now, I see a lot of lease agreements that are just so outdated, and they also have things in there that are unenforceable, like a 10% late fee plus $20 a day. If that were ever to go to court, that's something that's not going to hold up. Really, the maximum that we found here in Utah, late fee would be 10%. So you just want to make sure that you don't have anything in there regarding late fees that may not be enforceable, but also is clearly defined. When is rent considered late? Is it as the 5th? Is rent due on the 1st, but there's a grace period? You just want to have that clearly defined. Next one is a big one, pets. A lot of people don't want to allow pets, but you want to make sure that you have language in there. Some landlords are fine with pets, some are not. If you do have pets on there, make sure that you line out, okay, that there's a pet fee or there's a pet deposit. The more information you have, the better. Next thing we're going to look at is pests is another one. Now, especially in the summer months, a tenant may move in and within 2 days they're submitting a maintenance request saying that there's bugs in the property. Having a section that is clearly defines when is it the owner responsibility and when is it the tenant responsibility is crucial to help minimize any expensive. Also, right of entry. Now, this needs to be spelled out in the lease agreement because obviously if you're a tenant, you want to have the right to reasonable enjoyment and to be able to live in that property and not feel like someone's going to walk in the door at any time. But clearly line out that right of entry is something that you want to make sure is in that lease agreement. Utilities is another one. What is going to be tenant responsibility? What is the owner responsibility? Is the HOA fee paid for by the owner? Okay, then what is being passed on to that tenant? Typically, gas, electric will be in a landlord policy and in the tenant's name. name. Other things like water, sewage, and trash may be in the owner's name, but then the company or the owner's charging a flat monthly fee to help offset that. Now again, lease agreements can be kind of daunting. We just kind of touched on a couple of the sections that you want to make sure that you're highlighting. But if you have any questions about your portfolio, your lease agreements, and want to talk a little bit more in depth, there's our website, there's my phone number. Give me a call. I'd be happy to discuss our services and see if they could be a good fit. Thank you.